future payments are.
Punjab and Haryana, we have passed the same order. Punjab, Haryana, the same order of personal presence.
Right.
Provided if they come back here and file an IA saying that we have paid, then you can tell us. We will. You can mention, Parmeshwar, that these states have been. You can come and mention to that.
So that's so far as Rajasthan, Sikkim, Tripura, and Uttarakhand are concerned. Rajasthan, Sikkim, and Tripura the same order. Allowances have not been paid.
Rajasthan, Sikkim, and Tripura same order. And
Telangana has complied. Uttarakhand, the only issue is TDS.
All right.
Plus on TDS, I just one suggestion.
As for Sikkim, may I make one submission, my lord? May I request for a similar indulgence as the previous council? Once I file the updated status of allowances, may I make a request for exemption for appearance, as my lords have permitted the previous councils for other states? Because I'll get the updated status and ensure that the allowances are paid.
Let them yeah.
Yes,
let them hear.
Similar
let
request.
them appear, yes. Sorry.
As far as TDS is concerned, would you want to pass an omnibus order saying wherever the exemptions are applicable under the Income Tax Act, so far as allowances are concerned, no TDS should be cut, because there's no point in going allowances one by one.
Wherever exemptions are wherever exemptions are available under the provisions of the Income Tax Act 1961, from the deduction of TDS on allowances, the state government shall ensure that no deduction of TDS is made.
And wherever deducted, my lord will give them time till September to return that, because then this is complete deductions. It'll have to go back, because this is 1 minute. The state government is deducted so that
wherever the state governments have wrongly deducted the TDS, they shall refund the amount to the judicial officers on or before 15 September 2024, with liberty reserved to them to pursue their claim before the department.
I have with my note which I have circulated, I have put an appendix A where I have encapsulated under the Income Tax Act which all allowances that are part of the SNJP are exempted under the Income Tax Act. So my lords, if something like that can happen, and I've also annexed along with my note the payment slips of the judicial.
All right, what we'll do is that we'll take up, we have covered the states, right? On the issue of TDS ka baad mein dekhte hain. We'll keep it on Monday. Just look at what she has said, the allowance exam.
My only fear was that.
Can you serve the central government council so that we can then deal with TDS on that? Just ask Mr. Venkatraman to remain present here on Monday. You can tell him what the issue is, so that then we can clarify it.
Just housekeeping, sorry.
Yeah.
So then all those contents in the IS can be disposed of unnecessarily.
For Telangana state, my lord, no complaints. For Telangana state.
Where are they?
Page 26 of my.
Yes, there are 8 contempt petitions. Yes. Page 26 ko serial numbers 1 to 6 IAs stand disposed of.
Similarly, those 8 orders dated 22 of them merge in those contempt petitions also.
Telangana state, my lord. Telangana state.
27, there are number of IAs and petitions for intervention including prior to your watch. Those also can. Every time
all serial number 1 to 17? सील नंबर 1 to 17 का जो पेज 27 और 28 को है वो भी डिस्क्लोज
your lordships may mention on IA.
So what we'll do is
your lordship on IA lordship with your lordship's permission, Millers, may I?
Well, in the afternoon today, meet it. I'll just log in. The matters on Monday, including Re-Neet, also we'll take up on Monday.
May I have your lordship's time for just half a minute?
May I have your Lordship's permission to commence the proceedings? May I have your Lordship's permission? Communication has been received from Honorable the President of India. Upon their respective offices as judges of the Supreme Court of India, make and subscribe an oath or affirmation according to the form set out for the purpose in the third schedule of the Constitution of India, signed by the President of India. Warrant of appointment of Honorable Shri Justice Nomakapam Koteshwar Singh reads as under: by virtue of the power vested in me by clause 2 of Article 124 of the Constitution of India, I, Draupadi Murmu, President of India, do hereby appoint Shri Justice Nomakapam Koteshwar Singh, Chief Justice of the High Court of Jammu and Kashmir and Ladakh, to be a judge of the Supreme Court of India with effect from the date he assumes charge of his office. Given at Rashtrapati Bhavan, New Delhi, the 16th day of July in the year 2024, 25th Ashad, 1946 Shaka, in the 75th year of the Republic of India. Signed by the President of India. May I now request Honorable Shri Justice Nomakapam Koteshwar Singh to take oath.
I, Nomakapam Koteshwar Singh,
having been appointed a judge of the Supreme Court of India,
having been appointed a judge of the Supreme Court of India,
do solemnly affirm
that
I will bear true faith and allegiance to the Constitution of India as by law established,
that I will bear true faith
of India,
that I will uphold the sovereignty and integrity of India,
that I will do
the best of my ability, knowledge and judgment,
perform the duties of my office without fear or favor, affection or ill will,
perform the duties of my office without fear or favor, affection or ill will,
and that I will uphold the Constitution and the laws.
and that I will uphold the Constitution and the laws.
What's up with that?
Thank you, sir.
Warrant of appointment of Honorable Shri Justice R. Mahadevan reads as under: by virtue of the power vested in me by clause 2 of Article 124 of the Constitution of India, I, Draupadi Murmu, President of India, do hereby appoint Shri Justice R. Mahadevan, Judge of the Madras High Court, to be a Judge of the Supreme Court of India with effect from the date he assumes charge of his office. Given at Rashtrapati Bhavan, New Delhi, the 16th day of July in the year 2024, 25th Ashad, 1946 Shaka, in the 75th year of the Republic of India, signed by the President of India. May I now request Honorable Shri Justice R. Mahadevan to take oath.
I, R. Mahadevan,
having been appointed a judge of the Supreme Court of India,
having been appointed a judge of the Supreme Court of India,
do swear in the name of God
do swear in the name of God
that I will bear true faith and allegiance to the Constitution of India as by law established,
that I will bear true faith and allegiance to the Constitution of India as by law established,
that I will uphold the sovereignty and integrity of India,
that I will uphold the sovereignty and integrity of India,
that I will duly and faithfully and to the best of my ability, knowledge and judgment,
that I will duly and faithfully and to the best of my ability, knowledge and judgment,
perform the duties of my office without fear or favor, affection or ill will,
perform the duties of my office without fear or favor, affection or ill will,
and that I will uphold the Constitution and the laws.
and that I will uphold the Constitution and the laws.
They are all connected to Guwahati.
Yes.
He is the Pandit brother-in-law, right?
May I have your lordship's permission to conclude the proceedings?
The court will assemble for judicial work at 11:15 a.m.
I just circulated a note here. I have a note, Manoj. I have a very detailed note, Manoj.
You have the note here?
Yes. What is this kind of take the note?
Mr. Solicitor, that is the updated position you have now of who has...
That's, I have the updated position till yesterday night. Till yesterday night, we were served affidavits and compliance.
And they just now?
But I just wanted to bring to your lordship notice, this is the sixth or seventh time the lordships are asking them to pay up allowances and pay ballots. If your lordships kindly see the major defaulters, let me just point out from page 6 onwards. Well, that's a number of high courts have deducted TDS on allowances, my lord. So that issue I'll come to. But if your lordships...
Because allowances, you can't deduct
It is
TDS.
at all protected under section 192 and section 1014 of the Income Tax Act completely, because it is for money spent that allowances are paid. So there's no question of TDS, but I'll come to that a little later. If your lordships kindly see from page 6, Allahabad. Page 6 minutes. So lordship sees, so far as Allahabad is concerned, my lords, there is more or less compliance. I shouldn't take. I think there are minor difficulties which will get ironed out. So far as Andhra Pradesh is concerned, there is substantial non-compliance. I have marked
Substantial
non-compliance. Your Lordship sees the last two columns. So far as payment of revised allowances are concerned, and payment of arrears of allowances, my lords, most judicial officers have not received it. Most judicial officers haven't received.
Fixed, my lords, may just for payment of arrears. Right?
Possibly, I just wanted to bring to your lordship's attention. The seventh time your lordships are extending time. Repeatedly, your lordship, I have recounted all those orders in the first three parts of my notice. At best, my lords, August 15. There are states which have moved IAS asking for 6 months, 2 years. Orissa on its own.
15th August. 15th August.
15th August. All states, my lords,
a note has been submitted by Mr. K. Parmeshwar, then the Manisha-ur, indicating the status of compliance with the orders passed by this court on
well, it's three orders. Well, it's 27/7/2022,
27 July 2022 to 30 July 2023,
19th May 23, and 4th January 24.
19 May 2023
and 4th January 24.
Then there's 23rd November also, no?
That is only for extension, my lords. Your lordships again for the substantial order, your lordships.
And 4th January 2024.
24.
Full stop. Those seven opportunities, right, have been granted by this court to the states to comply. It appears that full compliance has not been effected, and several states are in default. Full stop. The note highlights the states in default, and we will deal with them. Full stop. They are dealt with CRETM, Andhra Pradesh, the Learned Standing Council, Learned Standing Council, Standing Council. Ms. Prerna Singh, appearing for the state of Andhra Pradesh, states that she has instructions to the effect that the payments which were to be made to the judicial officers have been made.
Whatever could be uploaded has been made.
Whatever could be uploaded.
Portal. There is a portal for the uploading of bills of arrears, which is the main. If my lords will see the last column, that is the main non-compliance that has been attributed to us.
Ms. Prerna Singh, Learned Standing Council for the state of Andhra Pradesh, Learned Council for the state of Andhra Pradesh states that the portal through which bills were to be uploaded that payments have been made to the extent to which bills were uploaded on the portal, on the web portal, which was opened for that purpose. We'll stop. Should we say, Mr. Parmeshwar, that this may be verified?
There's clearly non-compliance because judicial officers spoke to me yesterday night. Number of judicial, the All India Judges Association is also here, my lords. There is no doubt, my lords, most states have been lackadaisical.
All right. We will say that, on the other hand, both the amicus curiae and the All India Judges Association, which is represented in these proceedings, have categorically stated that that full compliance has not been effected. Full stop. We direct that a meeting be held. Meeting be held by Monday between the Registrar General of the High Court of Andhra Pradesh, the Chief Secretary.
Would your lordship then direct that committee to meet? Your lordship said institutionalized it, and that committee, all the relevant people are part of that committee.
Be convened by the committee appointed by this court in its order dated
4th January 2024.
4th January 2024.
SCDJ.
What do we call it?
CSCDJ.
The CSCDJ. Preferably on Tuesday, we'll say, preferably on Tuesday next, so that in case compliance is still to be effected, it is completed no later than by 15 August 2015. Full stop. A compliance affidavit shall be first shared with the CSCDJ and thereafter filed before this court, indicating compliance, failing which this court will be constrained to adopt contempt proceeding against the officers of the state if full compliance has not been effected.
Then Bombay, my lords. The lordship sees Bombay at page 8, my lords. Most of it is in substantial compliance except for the part so far as TDS is concerned. On TDS, the lordships will pass an omnibus orders on all high courts, my lords. Would your lordships only see, this is unfortunately, my lords, your lordships will see, if your lordships, the second last column, what they've been doing is many state governments have again tinkered with your lordship's order on allowances. After your lordship's order, there's no question of the state governments now saying that this is not permissible under our rules. We will not allow it. Mobile handsets can't be. Your lordships, remember during the hearing also this question on mobile handsets, ACs,
that we'll deal with separately.
Furniture, ACs. So an omnibus order on the count that there's no question of now deviation from your lordships.
That we'll deal with.
So far as Bombay is concerned, only this, because they have now said we'll take a call on mobile handsets and AC and furniture.
That we will.
Otherwise, there has been substantial compliance so far as Bombay is concerned. They have taken effective steps.
Which are the states which are not compliant?
Calcutta. West Bengal has moved an IAF for extension of time with us.
We'll give you a time till 15th of August to comply by 15th of August.
I'm only requesting some more time. It was 15th of August. Because I don't want to come back, seek further time.
It has to be, because 7 opportunities have been granted to us. All states have paid. I mean, how can West Bengal say we will not? Then you say that, look, then you can sit at home, will not take any work from judicial officers. They are all working there.
May I say this? It's only pertaining to arrears. Rest of the things have been implemented pertaining to the arrears.
Telangana state, my lord.
Not compliant, because in the amicus report it says virtually compliant.
How much have you paid?
They will not. None of the states are very smart. None of them will say how many judicial officers are there. They will say we have complied.
Once we
no details of this.
Shall come clear on this one. By filing everything follows. Because
I just for giving specific. May I just
State of West Bengal. There has been non-compliance by the state of West Bengal with the orders of this court. Full stop. The time has been 1 year's time is sought for effecting compliance, which is unreasonable. Full stop. We grant time for full compliance till 15 August 2024. Till we keep the matter for reporting compliance on 20 August. We'll keep the matter. We extend time for compliance until 20 August 2024. Full stop. The proceeding shall be listed on 23 August 2024, on which date both the Chief Secretary and the Finance Secretary for the state of West Bengal shall remain present before this court with affidavits indicating compliance.
All states, just bring to your lordship's notice, all state government and union government wanted with the 16, that was the 7th pay commission. We are on the threshold of the next pay commission, 2026, and yet our judicial officers after 8 years, 9 years haven't received it. It's not as if it's a separate case for judicial officers. Most of these recommendations are at par with state government and union officers.
We are constrained to pass the above order. We are usually circumspect in directing the personal presence of the officers of the state. Full stop. However, this is a situation where the officers, the bureaucracy has received the revision of their pay scales and other allowances with effect from 1 January 2016. Full stop. Judicial officers are yet to receive the revision, the revised pay scales and allowances. So the arrears which are due to them in terms of the SNJPC, so 8 years have elapsed. Full stop. Despite, as we have already noted, despite sufficient opportunities, there has been non-compliance. Full stop. It is in this backdrop that we have been compelled to pass the above order. So then,
instead of
I'll just take
bureaucracy, your lordship.
Circle it. Circle. You let me circle it. I can find anything if I circle it. So let me circle it.
Just one thing, Manoj may not say that State of West Bengal has not complied. Manoj may kindly say partially complied, as the amicus has stated, because it seems that we have.
but you have not told us how much you have paid. You tell us how much you have paid. Then we would have
I'll
recorded.
come back on this and just.
Anyway, you now you think all right. Which is the next one now?
Just only one thing, if just in case we are not complying by 20th, then Manoj may require the presence of.
Now here they have to remain present with an affidavit of compliance. Otherwise, we'll send them marching from here. Yes.
Plus, Chhattisgarh also concern is the allowances, but if your lordship, 1 minute, tax, God said there will be an
Tax will pass a separate order.
Again, the same thing in Chhattisgarh also. They will say we are considering whether we should grant those allowances. I don't understand those GOs. With all due respect, Manoj, after there is a Supreme Court judgment, the subject matter of all those GOs mentions the Supreme Court judgment of 4th January 24 and then says we will now consider whether we must grant those allowances.
Where is that in your note?
If your lordships kindly see page 10, Chhattisgarh Minutes, your lordships will see committee is considering upon the mode of payment of concurrent charge allowance. State has issued geo-dated so and so sanctioning increments on acquiring higher qualification, but no date has been mentioned. All that is clear in your lordship judgment. There's no question of now saying that we will deviate from your lordship judgment. And your lordship will see this.
State of Chhattisgarh, the geo issued by the state indicates that the committee is considering the mode of payment of the concurrent charges allowance, correct? The concurrent charges allowance. The state has issued a GO sanctioning the increments on acquiring higher education qualification, but no date has been mentioned for effecting compliance.
And out of 20, only 11 have been sanctioned.
And full stop, out of 20 allowances, only 11 allowances have been sanctioned. Full stop. The state, the conduct of the state of Chhattisgarh is plainly unacceptable. Full stop. Despite 7 opportunities, 7 there also, no?
Everywhere.
Despite 7 opportunities, the judgments of this court have not been complied with. We direct the personal presence of the Chief Secretary and the Finance Secretary of the state of Chhattisgarh before this court on 20 August 2024. 20 August bola tha na?
23rd minutes.
23 August 2024, together with affidavits of compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. All right, that's Chhattisgarh. Then full compliance by the 23rd. Yes, and the Chief Secretary and Finance Secretary have to be personally present in this court on that day. Now we are not going to say that if you comply with, then you need not be present, because then they will not comply with. Only if we now direct presence that they will comply with. We now know how to extract compliance with the orders. Yes. We are not going to send them to jail if they comply, but they have to be present here and tell us that they have complied. Nothing doing now. Yes. Which is the next?
Delhi, Manoj, page 12. No allowances, no arrears of allowances have been paid.
Delhi?
No allowances, no arrears of allowances. Last corner.
The NCTD, the government of NCTD has not complied with the orders passed by this court. Full stop. No case for extension has been made out. Full stop. We therefore direct full compliance with the orders of this court by 20 August 2023. The Chief Secretary and the Finance Secretary of GNCTD shall remain personally present before this court on 23 August 2023, together with affidavits of compliance for the purpose of reporting compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. Then,
Assam, no compliance. They moved an IA for extension saying citing floods because there was no floods in the year of.
Filed an affidavit, Lordship. Lordship, we have issued the notification. So far as 14 heads are concerned, Lordship, we have issued the notification, the report, because it came later, Lordship. That was the only thing, Lordship. The time, Lordship, that is being taken, Lordship, is we are really, Lordship, now facing disaster.
the council appearing on behalf of the state of Assam states that a notification has now been issued for the payment of 14 allowances.
14 allowances in the
Full stop.
Not 7, Lordship, 6. Lordship said 7.
There has to be full compliance with the orders of this court. Full stop. This court is not inclined to grant any further extension of time or exemption to the state. Full stop. The Chief Secretary and the Finance Secretary of the state of Assam shall remain personally present before this court on 23 ऊपर जो लिखा था ना 20th August and 23 August. Same order.
Lordship, our situation is a bit critical, Lordship, is because of disaster situation.
Yes, these are people who are working. These are people who are working in service.
Yes,
you have to pay them now and just give them opportunities.
Lordship, may I just submit, Lordship? Lordship has given time to the other state till 15th of August.
20th August we have given you. We have given you time until 20th of August, paid by 20th of August, and asked the Chief Secretary and Finance Secretary to be in court on the 23rd of August to report that they have complied. Then we will we'll put an end to the matter.
That may be exempted, Lordship. No. We are in a genuine situation.
Then I don't know what will happen. Then there will be another application for extension. Once we say this, the money will come.
Lordship, we are in a peculiar disaster situation, Lordship. We are facing it, Lordship, in the state, Lordship. Everyone is.
How much is the amount that you have to pay?
Lordship, I suppose it is more than 100 crores, Lordship. More than it will be for a state like Northeast, and we are facing floods, Lordship. It is the third round of floods. It is the third round of floods.
Ask the government of India to pay you. They'll pay you from some other head. Yes.
Lordship, Lordship, our case, Lordship, kindly consider.
No state.
The other states will not come out with this situation, Lordship. No. Our situation is a bit critical, Lordship.
We'll not do anything like
Lordship,
that.
Consider it on the next day, Lordship. On 23rd.
Still to remain, we'll see if.
Lordship, 23rd, if we don't show any progress, Lordship, kindly consider.
On the 23rd, if you are not able to pay, let the Chief Secretary and Finance Secretary come here and tell us why you can't pay. We'll consider your request. But they must remain present.
Lordship, that's what, Lordship, I was only requesting, Lordship. Kindly pass that order on 23rd, Lordship, if we don't do. No. Lordship, we are in a situation, Lordship. No. We are in a critical situation, Lordship.
Tell us from when did your judicial
otherwise I would not have pressed it, Lordship.
Tell us when, from what date did you revise the pay scales of your administrative officers?
That we have complied, Lordship.
From which day?
So far as the administrative officers. So far as the SNJPC, Lordship, we have complied with everything, Lordship.
No.
That I can't offhand tell, Lordship, from which date.
I'll tell you, 1st of January 2016.
Lordship, we have complied with every direction of the SNJPC, Lordship. We have complied with everything.
The point. We'll pay the state civil service officers. Judicial officers are not our.
Lordship, I am not making a legal argument, Lordship. I am not making a legal argument. It's on a different criteria, Lordship. It's only on this.
Who else, Mr. Parmeshwar?
So far as Guwahati High Court is concerned, Arunachal, Nagaland, and Mizoram, notifications are there, but release of funds is, according to the last affidavits, not comes. So your Lordships may direct the same direction so far as Arunachal, Nagaland, and Mizoram.
The same direction shall apply to the states of Arunachal, Nagaland, and Mizoram. Then,
for the state of Nagaland, all the information has been collated, is scrutinized, is just pending with the finance department, Your Lordship. There has been compliance. We've accepted all the allowances, Your Lordship. So kindly give us time, and Your Lordship may not.
Time till 20th of August.
Insofar as the presence of the Chief Secretary and the
we have to secure presence.
Because there has been substantial compliance. It's just the dispersal of funds.
The compliant come here, come visit Delhi once, yes.
Gujarat, I am now told there is substantial compliance except TDS.
TDS. That will just pass an omnibus order.
Himachal Pradesh, the affidavit doesn't give us any information, fortunately. So far as.
What is the position in Himachal?
Even there.
State of Himachal Pradesh में ऐसा लिखिए, the Chief Secretary and Finance Secretary of the State of Himachal Pradesh shall file a joint affidavit indicating compliance. Full stop. Since as of date, who's appearing for the state of Himachal Pradesh? Where is he? Who's appearing for the state of Himachal Pradesh? Learned counsel for the state of Himachal Pradesh is absent when the case was taken up. Is taken up. The Chief Secretary and Finance Secretary of the state of Himachal Pradesh shall personally remain present. Will be same order, huh? Let them come here. Yes. Then?
Jammu, Kashmir and Ladakh, no money is paid.
Jammu and Kashmir and Ladakh, same order as
complete non-compliance.
My lord, the for UT of Ladakh. My lord, in case of UT of Ladakh, my lord.
Yes.
My lord, in case of UT of Ladakh, all the funds are available with the two district judges, my lords, and the two district judges are the drawing and disbursing officers. The funds have been provided, my lords. The dispersal is with the learned district judges, my lords. My lords may have my compliance affidavit.
Regards the Union Territory of Ladakh, Mr. Piyush Beriwal, right?
Yes, my lords.
Learned counsel states that the two district judges are drawing and disbursing officers, and the funds have been placed at their disposal.
Yes, my lords. My lords, we have also filed an affidavit, my lords.
All right. So Ladakh really don't pass any order of presence.
Much obliged.
Jharkhand also same thing. There's no information on arrears of allowances.
Jharkhand. Have payments been completed? Have you paid all the 20 allowances? Then same order for Jharkhand. Ask the Chief Secretary and Finance Secretary to remain present. Time until 20th. Yes. Then?
Karnataka is not a concern, my lords. Karnataka is not concerned. Kerala, my lords, not paid. They have moved an application for extension. They have not
Kerala, pay. That's all right. You ask the Chief Secretary and Finance Secretary to remain present. Kerala, the same order. Compliance by 20th, personal presence on the 23rd. 20th of August and personal presence on the 23rd. Yes.
As Madhya Pradesh also same thing. SOP has been made by the committee, your lordships constituted, but no disbursement.
Madhya Pradesh is the same. Madhya Pradesh, same order. Then?
Tamil Nadu, my lords, not a single paisa.
Tamil Nadu?
Grave defaulter.
Same order.
Manipur had a problem, my lords, they moved an IA over.
With respect to the pay and pension, everything has been paid. The allowances, they have been approved. The prospective payment of the allowances have started, and I have got a pay slip from the respective ADOs also. Because with respect to the areas of pay, that is the only problem that we have. Because we were seeking a little bit of more time for extension.
How much do you have to pay?
This is about 24 crores. And the state is running into some deficit.
Yeah,
so
pay, get it from the Union of India. Same order for Manipur.
Can it be a little...
20th August, now 20th August. It's uniform for everybody, yes.
Meghalaya also, my lords.
Meghalaya?
Same thing.
Same order, Meghalaya.
Lords, Odisha, my lords.
You're from Meghalaya?
Instructions just now that the status was previous to end of financial year.
So 20th August. 20th August, ask the Chief Secretary.
My lords, I'll file an affidavit.
If you have paid, if you have paid, mention the matter earlier and tell us we have paid, we will exempt your Chief Secretary. But otherwise, we have to be present here.
Mention the matter.
But so far as Odisha is concerned, my lords, 6 allowances they decided not to do.
Orissa?
And so far as the arrears is concerned, they themselves decided that they will pay it over 6 or 7 installments.
Same order.
Lord, as far as the
6 allowances have yet to be paid.
Lord, as far as state of Odisha is concerned, the resolution of the Finance Department has come in on the 16th of March 2024, and the Law and the Home Department have submitted the proposal in the ensuing session for release of the funds in the Odisha legislature. That's the instruction which I have.
Learned Council for the state of Odisha states that the
the resolution of the Finance Department has been issued on 16/3/2024.
That the resolution of the Finance Department was issued on 16 March 24.
And the Law and Home Department has submitted the proposal for making the budget provision in the ensuing.
And the Law and Home Department have submitted proposals for ensuring payment.
The budget provision.
For making a budget provision in the ensuing budget session.
Ensuing judicial.
20th August, we are keeping compliant and ask the Chief Secretary and Finance Secretary to remain present.
Very well. Very great.
Yes.
And so far as Patna is concerned, with us, I am now told, yesterday evening I received a note saying that they have started disbursal of all the allowances. But the last affidavit which was filed, said that allowances have not been paid.
Then, yes, then.
That's Punjab and Haryana High Court, again, the committee filed an affidavit.
Bihar ऐसे लिख लीजिए, Learned Council for the state of Bihar states that an amount of rupees 122 crores has been transferred to the Law and Judiciary Department, right? And and the payments are being made in full compliance with the order of this court.
हम जा रहे कोई और कॉन्फिडेंशियल है कॉन्फिडेंशियली बनाया गया है तो एक मीटिंग करेंगे लोग पता चलेगा सर सही बात है देख लो उससे बात करता है मैसेज सॉरी आई गॉट बीसी अनमोल you don't need to come और मेरा मैटर आ ही रहा था बड़े पहला पढ़ेंगे
जल्दी हो गया था सब कुछ
3:30 तक आए तो ले ले यार पर अभी तो काम से मतलब है अरे जब ये
I just circulated a note here. I have a note, Manoj. I have a very detailed note.
You have the note here?
Yes. What is this kind of take the note?
Mr. Solicitor, that is the updated position you have now of who has.
Yes, I have the updated position till yesterday night. Then till yesterday night we were served affidavits and compliance. But I just wanted to bring to your lordship notice this is the 6th or 7th time the lordships are asking them to pay up allowances and pay ballots. If your lordships kindly see the major defaulters, let me just point out from page 6 onwards. Well, that's a number of high courts have deducted TDS on allowances, my lord. So that issue I'll come to. But if your lordships,
because allowances you can't deduct TDS.
It is at all protected under section 192 and section 1014 of the Income Tax Act completely, because it is for money spent that allowances are paid. So there's no question of TDS, but I'll come to that a little later. If your lordships kindly see from page 6, Allahabad. Take 6 minutes. So Lordship, see, so far as Yellabad is concerned, my lords, there is more or less compliance. I shouldn't take. I think there are minor difficulties which will get ironed out, my lords. So far as Andhra Pradesh is concerned, there is substantial non-compliance. I have marked
Substantial
non-compliance. Your Lordship sees the last two columns. So far as payment of revised allowances are concerned and payment of arrears of allowances, my lords, most judicial officers have not received it. Most judicial officers haven't received.
Fixed, my lords, we just for payment of arrears.
Possibly, I just wanted to bring to your lordship's attention. The 7th time your lordships are extending time. Repeatedly, your lordship, I have recounted all those orders in the first 3 parts of my notice. At best, my lords, August 15. There are states which have moved IAS asking for 6 months, 2 years. Orissa on its own.
15th August.
15th August. All states, my lords,
a note has been submitted by Mr. K. Parmeshwar, then the Manisha-ur, indicating the status of compliance with the orders passed by this court on.
Well, that's 3 orders. Well, that's 27/7/2022,
27 July 2022 to 30 July 2023,
19th May 23, and 4th January 24.
19th May 2023
and 4th January 24.
Then there's 23rd November also, no?
That is only for extension, my lords. Your lordships again. For the substantial order, your lordships.
And 4th January 2024. Full stop. Those seven opportunities, right, have been granted by this court to the states to comply. It appears that full compliance has not been effected, and several states are in default. Full stop. The note highlights the states in default, and we will deal with them. Full stop. They are dealt with CRETM, Andhra Pradesh, the Learned Standing Council, Standing Council, Standing Council. Ms. Prerna Singh, appearing for the state of Andhra Pradesh, states that she has instructions to the effect that the payments which were to be made to the judicial officers have been made.
Whatever could be uploaded has been made.
Whatever could be uploaded.
Portal. There is a portal for the uploading of bills of arrears, which is the main. If my lords will see the last column, that is the main non-compliance that has been attributed to us.
Ms. Prerna Singh, Learned Standing Council for the state of Andhra Pradesh, Learned Council for the state of Andhra Pradesh states that the portal through which bills were to be uploaded that payments have been made to the extent to which bills were uploaded on the portal, on the web portal, which was opened for that purpose. We'll stop. Should we say, Mr. Parmeshwar, that this may be verified?
There's clearly non-compliance because judicial officers spoke to me yesterday night. Number of judicial, the All India Judges Association is also here, my lords. There is no doubt, my lords, most states have been lackadaisical.
All right. We will say that, on the other hand, both the amicus curiae and
All India.
Yes, and the All India Judges Association, which is represented in these proceedings, have categorically stated that that full compliance has not been effected. Full stop. We direct that a meeting be held by Monday between the Registrar General of the High Court of Andhra Pradesh, the Chief Secretary.
Would your lordship then direct that committee to meet? Your lordship said institutionalized it, and that committee, all the relevant people are part of that committee.
Be convened by the committee appointed by this court in its order dated
4th January 2024.
4th January 2024.
SCDJ.
What do we call it?
CSCDJ.
The CSCDJ. Preferably on Tuesday, we'll say, preferably on Tuesday next, so that in case compliance is still to be effected, it is completed no later than by 15 August 2015. Full stop. A compliance affidavit shall be first shared with the CSCDJ and thereafter filed before this court, indicating compliance, failing which this court will be constrained to adopt contempt proceeding against the officers of the state if full compliance has not been effected.
Then Bombay, my lords. So Lordship sees Bombay at page 8, my lords. Most of it is in substantial compliance except for the part so far as TDS is concerned. On TDS, your Lordships will pass an omnibus order on all high courts, my lords. Would your Lordships only see, this is unfortunately, my lords, your Lordship.
Who appeared in this judgment? You appeared, my lords. You appeared for? The petitioner, my lords. The insurance company? Yes, my lords. Perhaps the insurance companies may not like this judgment, but we have to settle the law. In regard to the nature of the litigation, you have addressed our the execution of the disclosure voucher towards the full and final settlement between the parties would operate as a bar to invoke arbitration. Secondly, what is the scope and standard of that an application under Section 11, Clause 6 of the Act 1996 can be subjected to when a plea of accord and satisfaction is taken by the defendant? And thirdly, what is the effect of the decision of this court in interplay between arbitration agreements under the Arbitration and Conciliation Act 1966 and the Indian Stamp Act 1899 on the scope of power? Well, just quickly, what we have said is thus, even if the contracting parties, in pursuance of a settlement, agree to discharge each other of any obligations arising under the contract, this does not ipso facto mean that the arbitration agreement too would come to an end unless the parties expressly agree to do the same. The intention of the parties in discharging a contract by accord and satisfaction is to relieve each other of the existing or any new obligations under the contract. Such a discharge of obligations under the substantive contract cannot be construed to mean that the parties also intended to relieve each other of their obligation to settle any dispute pertaining to the original contract through arbitration. Although ordinarily no arbitrable disputes may subsist after execution of a full and final settlement, yet any dispute pertaining to the full and final settlement itself, by necessary implication, being a dispute arising out of, or in relation to, or under the substantive contract, would not be precluded from reference to arbitration, as the arbitration agreement contained in the original contract continues to be in existence even after the parties have discharged the original contract by accord and satisfaction. Our final conclusion is like this. The existence of the arbitration agreement as contained in clause 13 of the insurance policy is not disputed by the appellant. The dispute raised by the claimant, being one of quantum and not of liability, prima facie falls within the scope of the arbitration agreement. The dispute regarding accord and satisfaction, as raised by the appellant, does not pertain to the existence of the arbitration agreement and can be adjudicated upon by the arbitral tribunal as a preliminary issue. For all the foregoing reasons, we uphold and affirm the appointment of Justice K. A. Pooj, former judge of the High Court of Gujarat, as an arbitrator to resolve the disputes between the parties. But what is important in this judgment is that we have clarified our earlier judgment in Arif Azim. The clarification starts from para 126. We have explained how Arif Azim should now be construed or understood, or particularly in light of this pronouncement. And what is important is, just one paragraph very quickly, we are running late. Thus, we clarify that while determining the issue of limitation in exercise of the powers under Section 11(6) of the Act 1996, the referral court should limit its inquiry to examining whether Section 11, subsection 6 application has been filed within the period of limitation of 3 years or not. The date of commencement of limitation period for this purpose shall have to be construed as per the decision in Arif Azim. As a natural corollary, it is clarified that the referral courts at the stage of deciding an application for appointment of arbitrator must not conduct an intricate evidentiary inquiry into the question whether the claims raised by the applicant are time barred and should leave that question for determination by the arbitrator. Such an approach gives true meaning to the legislative intention underlying Section 11 (6) capital A of the Act, and also to the view taken in Re interplay. That's how we have decided. Thank you.
Very good.
May I just give everybody else, please circulate emails, because once we breach the norm, then I cannot breach it only for seniors, and I have to do that for everybody else. It completely destroys the system which I have put in place. Everyone who has a request, please send me an email. I'll look at it by the afternoon today.
No, this is not a listing request. It is not a listing.
Anybody who does not have a listing request, some correction in an order, something is free to mention.
Probably there's a factor coming tomorrow. We're asking the review today to be put with that tomorrow. That's a request.
That also has to go on an email. That's a listing.
I'll put in the email.
Listing, if it's on listing, please don't mention. Please put it in an email. I'll look at it in the afternoon today. I promise you I'll do that. Same thing. When was the impugned order passed? By 19th, right? So we'll list it tomorrow.
Your Lordship, I'll just see.
But you could have also said it in an email. Sorry. Circulate a rejoinder.
Circulate a letter in tomorrow's matter listed at item 26. And for the respondent, this needs to
be late now. We'll see tomorrow. Yes.
I'm mentioning a matter where I've already sent emails for us. But also I've also sent
it will be dealt with.
There's only one meeting.
Sure.
Just a query, would your Lordship be taking the part-heard income tax matter or...
just wait, I've just told the court master, we'll tell you in a minute, yes.
I'm sorry, I just one request. There's an order that your Lordships had passed last week, Your Lord. It's an arbitration petition.
Lordship perhaps will recall notes, I had made a submission that the pendency or the reference to arbitration will not impact any criminal proceedings that we might initiate. Because our recollection is the Lordships had dictated that in court, but it's perhaps not reflected in paragraph 3. Your Lordship,
we also said in the course of the discussion that an arbitration will never affect a criminal prosecution.
But I made that submission, I think.
All right. Well, you don't have to put something, clarify something which is obvious.
Right.
So before we begin, what we're proposing to do is that we have the income tax partnered group. Neet is about that today. We'll at least open the Neet matter, and then we'll see what to do with the partnered group. We'll hopefully start with the partnered group, but it might just have to wait until we open the Neet matter, because there's some urgency in the Neet matter. Young students all over the country are waiting for the outcome of this matter. So, but we are not going to lose season of the income tax matter, because we are now also mentally we are in the matter.
But may I suggest, since we have circulated something yesterday, it can be kept tomorrow also.
Let's at least open the Neet matter today, because let's see the matter.
The others can be discharged, etc. Many are procedural matters, item 4, etc.
So what we are doing is, procedure number 1, for instance, is about bifurcating. We'll take up item 1. So it's bifurcating matters, etc. That will pass procedural direction.
For compliance like that, when you're not
right. We just yes.
Item 1 is not a bifurcating. Item 1 is a batch of cases on fringe benefit tax.
Yes, the fringe benefit.
Come on some other day. Yes. The bifurcation is the gaming matter, I think, if I'm not mistaken.
Why is that listed for direction? Because item 1 is only this.
No, there are two after transfer petition.
The courtmaster says that we have to pass the usual procedural direction for appointing nodal counsel, so that they prepare one common compilation. So tell us who will be the nodal counsel.
That's right. Mr. Cooper, I'll give my AR's name to your Lordship's bench, and one from the department. So 2 of us can be there.
Is there by lunchtime? For the department, is there a compilation for the
only?
So now tell us, for the petitioners, who will be the nodal counsel?
I can volunteer. Mr. Kunal Kishore can.
And what since you've already prepared.
Manisha-ur, I've already our compilation.
And for the department, Mr. Venkatraman, are you appearing in the one? You are appearing. Who will be the nodal counsel there?
Mr. Divakar.
Mr. Divakar. So Ms. Manisha-ur and Mr. Divakar will be nodal counsel. Usual orders. And prepare one common compilation duly indexed with written submissions in terms of our last circular. And file it by what date will you file it? Mr. Datar, by what date will you file the compilation?
Your Lordship is posting it in August or July?
We'll post it in August, so we'll give you enough time to file the compilation.
Yes.
You can file the compilation including written submissions by the 30th of July, and we'll place it in August. Alright, so that seal number 1 is over. That way, we have just one compilation, otherwise it becomes impossible to.
Please,
Item 2, canon matter, the procedure direction now. It has to be, bench has to be constituted. The act of batch of matters there.
So here also, can we have one compilation, please?
Yes, we can do a compilation.
Right. So who will be the nodal counsel?
I will.
Charanya will be the.
From our side, V. Chandrasekhar Bharti will be.
So
panel host.
Charanya Lakshmi and Mr. V. Chandrasekhar Bharti. And can you prepare the submissions and compilation by 31st of July?
Definitely.
Then we'll keep it in the first week of August and we'll take this up. Because a lot of matters across India are dependent on this.
Pending.
Thousands.
The thing is, very much. Because this matter, the canon matter was passed by 3 judges.
Right.
Therefore, it has to be.
It has to be 3 judges. It will be before this regular bench. Yes, it will be before me and my 2 colleagues. So we are seized of the matter.
As it pleases.
Item 3, Google matter. I appear for Google. Your Lordship recalls your Lordship.
What we'll have to do is, are the compilations ready in Google?
Yeah. Everything is done, but give dates in September.
Today we started only because we have the Neet matter, and literally lakhs of people all over the country are waiting for the outcome of this matter.
No, in September, Manoj. Give dates in September.
Probably in the first week of September, so that we can.
Manoj, a little later, I have the Indus Valley dispute before the neutral expert in September.
Second week of September, Marathon.
After 15th, Manoj. After 15th, any day.
Submissions have not been received, the courtmaster says, so you'll have to email them.
That will make sure are sorted out.
Why don't you give us on the side of Mr. Salvi one nodal counsel?
Yes, I filed it. We filed it on the 3rd of October. We'll file it again.
send an email again. It's been fine. All
Okay. Who's the nodal counsel on your side?
So Mr. Chandelier is the nodal counsel.
Mr. Chandelier. And what about Mr. Venkatraman?
Already said
We already appointed nodal counsel. All right. Then make sure that that is filed by the 31st of July. All right.
Gaming matter. This again the gaming matter.
Are these absolutely ready for
Union members have signed its council. Lordship had directed the House of Finalization to be filed appointed nodal council that is not number 2.
We set down 31st of July for completing the filing of the compilation.
Identity of a kicking match can get excluded, but amongst gaming, no segregation, Lord. Everything has to be heard here.
Agreed. My friend is right.
This exercise has been done in the registry.
Yes.
The gaming matters we've got separately listed and the anti-profiteering are separately.
Correct.
So they have to be segregated. Now, what we will do is that the learned council can. This is being done by Charanya.
The list is made. Charanya's
I will look at it.
just take it up now. Just
Right. Ms. Charanya Lakshmakumaran, learned counsel appearing on behalf of the petitioners, some of the petitioners, has prepared has prepared a tabulated statement segregating the into single inverted commas, gaming into inverted commas matters from the into single inverted commas anti-profiteering matters. Full stop. The statement is reproduced below. Copy कर लीजिए. Mr. N. Venkatraman, Learned ASG, states that he will have this duly verified within the course of within a week. And intimate the registry in regard to whether on whether these reflects the correctness of the statement. Full stop. This may be communicated to the court master no later than by date on the email ID. The compilations are ready.
The counter was received by us in the writ petitions on Monday evening. So we need some time to file the
Joint has to be filed. That may be filed on or before 31 July 2024.
Lordship, some of the transferred matters, the councils indicated that they would also like to make written submissions when we checked with them. So they were waiting for direction.
All right. If any further written submissions are to be filed, including the transferred cases, they may be filed with the nodal council to the common compilation. So the written submission shall not exceed 5 pages each. Because
would your lordship set it down on 31st for directions? Absolutely. Would your lordship have it on 31st for directions, Manoj?
We'll have it on the 31st of July for directions. For directions on the 31st, which is a Wednesday.
The game lordship will be taken first.
All right.
Directions.
I not segregated.
We are segregating gaming and the two sets
anti-profiting.
There are no difficulty in segregating gaming and anti-profiting. Now, any segregation within gaming is not acceptable.
No, we are not asking for it now.
Somebody asked and said game of steel should be segregated.
Mr. Venkatraman, now you're giving them ideas.
Yes, correct.
No games. All right. Now, so that covers 4, 19 and 20.
Anti-profiteerism game.
So 31st of July, we'll keep it for directions.
Yes.
Just to ensure that everything is complete, then we list it immediately and advertisement.
Obliged.
Matter, because this is for the gaming matter, now the counter, etc. we have read. For anti-profiteering matters, there are no directions in terms of
the circular.
Right. So for the anti-profiteering matters, we'll issue similar procedural directions. Same nodal council?
Can be then.
Same nodal council, same. And by 31st July, that process must be completed.
We can go then.
Okay. That is neat.
Please balance.
Mr. Ide, we'll now stand back the income tax matters. We are not adjourning it for the day, but in view of the importance of the NEET matters, we'll take up the NEET matters, because but all the other learned council may step aside and you can have a little time off, but we'll take up the income tax matter because they're not taking up any other heavy matter until we take up that. So NEET only because of the social ramification, we thought we'll give priority to the NEET matter. All right, now
They're all mixed up. 5, 7,
9 is all that.
Now, who's going to open the arguments in the NEET matters for the petitioners?
My lord, my item 5 is slightly on a different footing. I am showing not merely the leakage of the examination, but I am showing the...
Because 9 is the first matter wherein the...
Mr. Dwivedi, where are you appearing in this matter? This is pension matter. I think you are safe today because, after this, we are going to take up the parted tax matter, which will take the rest of the day. So, but the judge's pension matter is again important and we will take it up probably next week. We'll list it and take it up. Just a little adjustment to the board, that's all.
It's sort of as item 7, again, the writ petition under Article 226 of this candidate is pending before Honorable High Court of Delhi. He has filed writ petition under 32 before this Honorable Court also, saying that I will withdraw that. This is the third time consecutively where he is alleging that my OMR has been replaced, which is actually...
All right. That we will see what to do there, because that's not about the systemic issue, but about his own OMR. There we may be who's appearing. Which one is that? Still number?
Item 5. 514.
So 5, why don't you do this? Go to the High Court. Whether your OMR sheet has been replaced or not, there is no systemic issue.
High Court has already passed the judgments. High Court has refused to examine this issue. My lord had delegated.
So why have you filed a writ petition? You have to file an SLP then.
No, my lord, in 2020 I went before Honorable High Court on the directions of this Honorable Court.
Now High Court is held against you.
In 2021.
21 hoga, 20 hoga, 19 hoga, 23 hoga.
Lord, since that,
but now tell us what remedy do you have against that judgment of the High Court?
Against that, even if I come in SLP, my lord cannot grant me an admission. My lord, I am saying I reappear in the examination in the...
We'll entertain your writ.
Yes.
On one condition that now then we will treat the order of the High Court as attained finality.
Yes.
So we will then hear your writ on the footing that the order of the High Court has attained finality. So you are taking a chance.
My lord, High Court refused to examine the issues. That's the final.
All right. We'll see. We'll see when the matter is called in.
My lord, may I...
Mr. Amutu, we are seized with the matter. We know how important it is. It's about our own retired judges. But we have the NEET matter today, so we'll give priority to the NEET matter today. We just indicated to Mr. Dwivedi, we'll try and accommodate it sometime next week, so we'll take it up immediately. We'll just give me a little time, so I'll just in the evening discuss the board position with the court master, and then we'll take it because we have to take it up.
Pilot, I'm here for item number 6. I have the same prayer that my OMR sheet was replaced and the...
All right, let the matter open up now. If everybody just keeps on giving a ridiculous time, who's going to open the hearing?
Yes, mine is the first matter where they have filed their responses.
So we'll hear Mr. Huda first.
Yes, Milord, I'll supplement whatever he said.
All right, and then we'll hear the solicitor.
Your Lordships had an occasion to go through the second status report.
Yes, we have seen the second status.
There is something is crystal.
You have seen the second status?
Yesterday.
Yes, I saw it in the morning today. Both my learned brothers have seen the second status report.
Wait, please, Ross. No.
This is yours.
Just one suggestion. Okay. Okay, first page.
In item 5, may I please request that the first pair is my lord that...
You are not arguing it. You have somebody before you who is to argue his matter.
They are in item 7 and item 5 I am making a request.
So which is the lead prayer? Which is the lead matter? Are you prepared to argue the whole matter on the leak, etc.?
No, I'm not on the leak aspect. My lord,
why are you interrupting the flow of the proceedings, Allow somebody who is arguing the main matter to take charge. Right? We'll hear you at the end, no problem. Practical since not supplied.
Wait, please. Good. 2-3 things at the outset, Lord. As per my Lord's direction, CBI was supposed to file their status report. Filing, we understood it will be filed and it will be supplied to us. And that was the direction.
The problem is this. The only problem is this today. I mean, I'm all for transparency. In fact, this is not a sealed cover procedure. Let me be very clear. But today an investigation is going on.
I follow that.
If what CBI has told us in the course of the investigation is revealed, probably the investigation will get scuttled because people will become wise on what are the leads which have emerged in the course of the investigation. So that's
I bow down straight away. My only, you see, the intervention in between will cause a problem. And
so what we would like you to do, Mr. Huda, is you have to, redaction is not possible in these kind. If it's redacted, then it'll have nothing of it'll have nothing of substance. You will have to show us, prima facie, on the basis of your submissions, that the leak is so systemic and has affected the entire examination process across the country that we must cancel the examination and direct a fresh examination to be held. Yes. That is the area where we want to hear you. And then we hear the learned solicitor in response to that.
I will assess this honorable court.
Just 1 second. Second, we have some ideas also on what we are going to pose to the solicitor thereafter.
Yes, ma'am.
We would like you to assist us on assuming, if we accept your wider submission that you must have a fresh, neat examination, then that's what you exactly want. Suppose in the alternative, after hearing
तो काफी डैमेज हो गई। नो प्रॉब्लम, मैंने पॉलिसी बाजार को बुला लिया। सर, कार का रिपेयर और क्लेम सेटलमेंट सब हम संभाल लेंगे।
इतनी जल्दी? काफी महंगा कार इंश्योरेंस लिया होगा।
काफी सेव किया पॉलिसी बाजार से।
पॉलिसी बाजार पे कार इंश्योरेंस कंपेयर करके 8,000 रुपए तक बचाओ।
मोटोराइजर 50 अल्ट्रा ने फ्लिप फोन की दुनिया को ही फ्लिप कर दिया है। मोस्ट इंटेलिजेंट फ्लिप फोन। इसमें है AI फीचर्स और बहुत सारी ऐप। 4 इंच का कवर डिस्प्ले आता है। इसका कैमरा अमेजिंग क्वालिटी का है। IPX8 अंडर वाटर प्रोटेक्शन इज ट्रूली अ स्टैंड आउट फ्लिप फोन। मोटोरोला Razr 50 अल्ट्रा।
Hello, Moto.
I'm assisting. I'm not saying that. But the handicap I have in assisting this honorable court in this leak matter, one, they have not declared the entire result. They have declared the result of 100 people. And my assistance is information gathered from here and there. The UPSC not in IAS exam, they declared the result of entire people. At least they should have declared the result of this 1 lakh people who get admission, first 50,000 in the medical colleges. And the 2 handicaps may kindly notice I will have in the course of my assistance to this honorable court.
Plus 50,000. How many seats in the government medical colleges?
56,000. And would everybody clamor for these first 56,000? Even the people below 56,000 may be willing to go for a re-examination.
And how many in the private medical colleges?
52,000. 56 and 52. That is 1,08,000. Now, if re-exam happens, literally it is, if all of them do not want re-examination, the total number is 1,08,000 people, not 23 lakh people. The remaining 22 lakh people
have not got admission at all.
Have not got admission. So they are willing.
Except for the fact that if some people have wrongly got into the 1,08,000 category,
that's right.
Then somebody below the 1,08,000 can legitimately get into that 1,08,000.
That's right. So, but in fact, the balance is this 1 lakh. If all of them 1 lakh don't want re-examination, this 1 lakh on one side and 22 lakh on the other side who would like to take a chance in view of the this examination is marred by controversy. All 22 lakh would like to have a second chance.
That argument, yes, Mr. Huda, there is a problem. Forget the question of leak in this matter. Merely because, say, out of 22 lakh, 108,000 only have got admission or would get admission, and therefore you are left with say about 20 lakhs, 22 lakh students who would want to take a chance. We cannot order a re-examination merely because they want to take a chance. Re-examination has to be on a concrete footing. That the sanctity of the entire examination has been.
I bow down. I just wanted to dispel an impression that the stake in the re-examination is of lakhs of people. No, the stake is of 108,000 people. I will have to set up, demonstrate conclusively that we cannot segregate tainted from the untainted. In Tanvi Sabharwal case and the judgment authored by Malone clearly says in Tanvi Sabharwal's case, the finding was we have identified 44 candidates out of 6 lakhs. The remaining we are not able to identify. So we cannot permit even 10 people.
So I think you need not labor that point because you're absolutely right on that.
I'm so great.
That if you can, conceptually, that if you can establish that it is not possible to segregate the tainted from the untainted, then the whole exam will go. Because those basic, you can of course show those authorities briefly to us at a certain point. But when we have looked at the facts, but before we go into the authorities, we want you to address the core of the facts before us.
I will try to first summarize my case and then elaborate. So that has an idea what I am saying.
So you can summarize now. My brother Justice Pardiwala would like to know, out of 108,000, totally how many petitioners are before the court?
But it is NTA can say,
NTA, 38 petitions. Now you're for NTA, no?
38. The transfer petitions made by the NTA.
So 38 petitions includes the 6 transfer petitions or the transfer
petitions before this honorable court would include the 6 transfer petitions made by the NTA. So 32 petitioners, 32 petitions.
Our question is little.
I represent 10. I'm from
how many are asking
supported by 43 I do not know how many, at least 100 the candidates who have called us individually but who have not been.
Actually, they have a figure. 108. Mr. Kaushik, if you can just ask somebody, any of your team from the NTA, to just do this physical exercise of telling us even at lunch or after lunch, how many total students are involved in the matters before not involved, but how many students have moved the court in this batch of cases?
I have not seen that was respect, my lords. That way, approximately 108 are seeking reconduct of the examination.
Council,
50.
108 who are seeking re-exam are amongst 108,000.
No, yes.
No, they'll be outside 108,000.
They are outside 108,000. They plan to be.
Because 108,000 would get. They
are not seek re-examination at all. I represent.
So all those who have not been able to.
Yes. Some people within 108,000 are also before your lordships because they say
they will not get into government medical.
They will not get into it.
In my
seeking re-exam.
In my case, 700. In my election, there are 5 candidates. One of them.
Now in charge, unless we ask a question to some other council, the others may not interrupt because otherwise, our line of thinking is also affected. And he is deflected also. He has his thought process on some matter. Yes.
Out of total.
But they are not in mission.
I'm on your side, man.
Also, Manisha had a point. What is the minimum mark which has been received by the petitioners before the court? You need not give us an offhand answer. Just do it at lunch and tell us.
Can I one thing, my lord? In 5 petitioners in my petition, my lord. One is having 700. Another is having 600.
How will we be able to just wait for a minute? Let's have the conceptual basis of the matter. We can't go in individual facts like this. Let's have the concept very clear before us, and then we can see where the balance lies. Yes, Mr. Uri. We hear you, and we are here to hear you and do justice to the matter.
Thirdly, qualifying marks are all 64.
Under this exercise, there are 131 students who are not falling within 1,08,000, and they are pretest.
131 students.
And they are petitioners, and there are 254 who are falling within 1,08,000. They are opposing them. Not that statistics can assist your lordship either way, but factually this is the position.
So 131 students beyond 1,08,000 who want a retest, and
254 they are in the form of IAs or implement
who are opposing.
Opposing the retest. They are found within 1,08,000.
The figures may not always be right, my lords, because I represent somebody who falls within.
Yes, that's true.
And whose rank is about 2009. But, so, my lords, we'll work out the figures in common with Mr. Paul.
Tell us also what is the cutoff rank for the 56,000 and for the 1,08,000.
May just one clarification, conceptually. Anybody who is above the 50th percentile qualifies, in the sense that if somebody above them also does not go into medicine, goes into IIT, for instance, there will be a figure. So passing is 164. Passing is 164, but admission is a dynamic process, may stop at 1 lakh, may stop at 1,50,000, and depending on the particular quota or reservation or whatever is available. 164 is the cutoff mark. 164 means that you are above the 50th percentile. So about half the people have a qualification to be allotted a seat. Not everybody will be allotted a seat. So it's a dynamic process. There is 1,08,000 seats available. Some of them may not opt for medicine, some may go into IIT, this, that, and the other. The figure will come down. And also depending on whether you have a reserved category or something. So it is not, so it is dynamic, but roughly saying, I think the last figures will stop at 2.5 lakhs, ranked wise. That's
it. Let's hear Mr. Budan. Yes, Mr. Budan.
So, Lord, I am starting.
Can summarize your case, you say?
Yes, I'll just summarize. But it will give me a space. It's for the picture. Lord, I am starting with a handicap. I do not have the result. Because of that, I cannot have the data analytics, which the state has placed, NTA has placed on record, giving the bell curve. And Lord, one of the director of IIT Madras is a member of the governing body of NTA. They have run the data analytics process, taking the entire number of 23,33,000 candidates who sat in the examination. If data analytics is to be run to 23,33,000 people, at what stage 10,000 or 20,000 people have sneaked into it? This data analytics running into half a page, which every dot means thousands of people. You cannot detect any abnormality when you draw a bell curve, which is based on 23,33,000. The correct procedure, if at all they were doing it, the correct procedure was to apply this process to 1,08,000 people. The first 1 lakh people in 2021,
22, 23 and 24. Probably the curve would have been able to catch 1,000, 2,000 people going up and down. Now even 1% is up, is into thousands of candidates. This Honorable Court has not tolerated even if it comes to a conclusion that 1,000 people have entered into the system of this 1 lakh, which we are not able to detect. This examination cannot be sustained.
Okay, that's one aspect about what IIT Madras has done. Now, what about how do you develop now? You can develop the basic cases.
I'm demonstrating that IIT Madras can't be relied upon.
Because they have taken the entire body of 21.33 lakhs. And according to you, that data analytics should have been done on the restricted figure of 1,08,000 and compare that with 2021, 22 and 23.
So great. And the governing body member is the of NDA is the director IIT Madras. There is a conflict of interest.
No, but therefore, you take it, I mean, what is at the highest, what does that lead to? Your argument is that the data analytics has been done by NTA itself.
Correct.
It can't be higher than that. That's because the director of IIT Madras is also on the governing body of NTA. Because
actually
is not there.
But he says he is not on the board of directors of NTA.
Oh, I see.
He was an outsider whose not expertise.
But anybody from IIT Madras who is on the governing body of NTA?
He was. Somebody else was.
Was means in the past.
In past.
Today IIT Madras says no, nobody from IIT Madras in NTA.
When was that password when he exited? But the person, the director who has prepared this report.
Mr. Solicitor, just sit for a second and ask them what the position is so that you can have a seat.
Where you a member of NTA? This is not the way it is done. Please don't do it.
I have not attended any board, nor yet.
He is not a member. Any other person is a member. Person supposed to be with them. When? I said now, yesterday,
check to further verification. But IIT, whichever IIT organizes JEE examination, IIT JEE for selection, the chairman of that examination committee is ex officio member in NT. But the office, the director who has prepared this report is not the member. Some Mr. Gopal.
Now, IIT JEE for 2024 was held by IIT Madras or who else?
IIT Madras. He is the chairman of that IIT JEE examination committee, but he deputed somebody to attend meetings of NT.
Oh, I see.
He ex officio is there to use his expertise.
So I'll just take it down. IIT JEE for 2024
was conducted by IIT Madras.
Yes.
And the chairman of IIT who conducts IIT JEE, ex officio is a member of NTA.
And what role does NTA have in regard to the IIT JEE?
Nothing.
There is no.
He is not.
Let's ask the director.
It's NTA conducts JEE.
So the actual NTA, the actual IIT JEE mains are conducted by NTA.
Yes.
Oh, I see. So IIT Madras would only set the papers or what happens?
No, they would conduct the examination. Advanced they conduct JEE, mains is conducted by NT.
So mains is conducted by
NTA.
By NTA. That's like the preliminary exam. The mains.
Advanced is like, advanced is only final. This is only for IIT. Whosoever is intended to get admission in IIT, they opt for advanced. Otherwise, all other
the admissions are on the basis of IIT JEE mains. And IIT JEE advanced, NTA doesn't conduct that. So IIT JEE advanced is conducted by whom?
NTA.
No.
This is conducted by IITs.
IITs or one IIT?
One IIT. It is conducted by IITs. One become the organizing IIT. This year it was IIT Madras.
Okay, so like the class.
Yes.
So this year, the IIT JEE Advanced, the organizer was IIT Madras.
Correct.
Okay.
And he has gone into city-wise as well as center-wise analysis.
Now, when you said that the chairperson of IIT JEE is an ex officio member of NTA, of the government, is ex officio a member of the governing body.
The governing body has no correlation with the activities of the conduct of the exam.
So the IIT JEE, the chairperson. So this time, who was the chairperson?
I think the same chairperson.
He was the chairperson. He deputed one Mr. Gopal Krishnan to attend the meeting on his behalf.
No, but who was the chairperson? The director of IIT Madras was the chairperson?
Because IIT Madras was the organizing body.
So IIT Madras was the organizing body both for the mains as well as advanced, only for advanced.
Only advanced. Mains was conducted by NTA, by us
entirely. But IIT Madras's director was an ex officio member of the
governing body, which is a
of NTA. Of NTA. And is he an ex officio member only for this year or generally?
He would be, whichever IIT conducts the exam.
For that year, he becomes a member of the government. All right, got it.
But I must take the lordship's note that what is placed in the report is not for, say, a city-wise spread of top 100 ranks.
This time, the director IIT Madras would be ex officio member of the governing NTA, but he had deputed somebody else on his behalf to attend the meetings.
One Professor Gopal Krishna. And I have city-wise and center-wise. That I am explaining.
But deputed professor or doctor?
Gopal Krishna. Professor Gopal Krishna. If a learned fellow is going on the question of bias, that may not help here. I have said with him, Lord, I have examined everything which he has done. I can show it to your lordships, and Lord, it is city-wise, center-wise, and at the national level. Yes, Lord. Just so that there is no...
That can indicate when your turn comes. All right, now tell us.
Without showing the document, Lord, that city-wise and center-wise, the first table is, Lord, the bell curve of 23,000 people. 23 lakh people. The second table is city-wise top ranker analysis, the top 100. How top 100s are spread over across the cities. Then there is a table which gives
Let me do this, Mr. Huda. To understand your submission, can you just look at the report of IIT Madras?
Yeah, let's
go straight there because let us first understand what they have done.
Yes, that's great. Lord, may kindly see the reply filed by them on 10th of July.
Just one second. Serial number कौन सा है भाई?
Additional affidavit dated 10th of July filed on behalf of respondent number 2.
Okay, dated 10th of July?
Correct, Lord. That's right. Lord, this is respondent number 2. Annexure A. Page 12.
Page 954. यही नहीं बोलता. Analysis of the 17 candidates or no?
Lord, this annexure is data analytics of NEET UG 2024, annexure A.
Lord, it may be part of the petition filed by Shivangi Mishra. Shivangi Mishra, that was the first.
Yes, it is in Shivangi Mishra's case, Lord, because they didn't file it in my case.
Yes.
Yeah, we got it.
But copies are served on.
Yes, copies are
report from IIT Madras, page 12 to 18. Let's see that.
Yes, now, you see, at page 12 is there's an executive summary given on page 1, and then the charts. Executive summary indicates they have gone all the way to explain. If I can read it, the executive summary.
Yes.
Mass distribution follows the bell-shaped curve which is witnessed in any large-scale examination in
just 1 second.
Yeah. Executive summary, short summary. Marks distribution follows bell-shaped curve that is witnessed in any large-scale examination, indicating no abnormality. City-wise and center-wise analysis done for 2 years, 23-24, to find out if there are any abnormal indication. Analysis is carried out for the top 1.4 lakh ranks, given that the total number of seats across the country is around 1.1 lakh. This analysis is granular enough to indicate any abnormality had a large number of students gotten into high rank top 5% due to malpractice, or if students from a particular exam center or city were benefited. The analysis show that there is neither any indication of mass malpractice nor a localized set of candidates being benefited leading to abnormal scores. I would say this is beyond their belief, what they are stating here. D. There is an overall increase in the marks obtained by students E part. There is an overall increase in the marks obtained by students, specifically in the range of 550 to 720. This increase is seen across the cities and centers. This is attributed to 25% reduction in syllabus. That's what they are for them to say. In addition, the candidates obtaining such high marks are spread across multiple cities and multiple centers, indicating very less likelihood of malpractice. But if I can take just one moment here. NTA, the Government of India, in their reply is talking that they are attributing 2 reasons for this exponential inflation in the marks. 2 reasons are there is 22 to 25% syllabus reduction and hence the inflation. 2, increase in candidates. Nowhere there is a whisper that there was increase in the syllabus that we have placed on record. If not more, at least corresponding. So, if I can say so, the reply is not giving a full disclosure for oblique reasons. If they are talking about deleting the syllabus, they should simultaneously talk about increase also. At least they should disclose it. I will show the increase part of the syllabus. I will come to it. So there is an increase and decrease both. But this IIT Madras is talking about 25% reduction. Probably they are not given the papers that there is an increase also. And why IIT Madras will not?
Let's look at the data.
Yes. Now kindly see the first table. This table blood is for 23 lakh people. They say it is a bell shape. And any large examination will have a similar kind of a shape. And hence, there is no red flags. Now, starting from extreme right, where 720, now it is going up to the marks. Now, at every stop, there are thousands and thousands of people. This one line, which encapsulate about 24 lakh people, cannot give them any abnormality if 10,000 have gotten into this system through a back door and there is an inflation. Inflation is admitted. Leak is admitted. They are trying to justify it that it should be the same curve, and it is the same curve. So this is no indication that there is no abnormality. That is my respectful submission. Because of the data is too large, which can't be caught.
granular variations can't be seen with this large data. Yes. Now we'll make kindly see the next table. They say the city-wise top ranker analysis. Plot of the marks obtained versus number. Of candidates for all the candidates who took the examination. Similar if they have run it for top 100, they should give for top 100. That will include Hardayal School, Bahadurgarh, which had 8 candidates from the same center. Now, they are leaving us in darkness because they have the data, we do not have a data. So whatever they are saying, we are trying to analyze and find that is it correct or not. Now, the same story runs through all their tables. Can you see the next table?
Maybe. But I can give, there is no difficulty. Just to
all right. I'll read the narration also.
Only a minute, just to give the context. This chart shows that out of students who got first top 100, and we are not counting those 1563. Please don't count them because they become a separate class.
My only objective is why send only for 17 people? Why don't they give a data for 100?
I'm answering that. Please allow me to. If you listen to it. In Bengaluru, just to show the difference, in 23 there was 1, here it is 5. Maximum in India, the city which got 100 ranker is 5 in Bengaluru, Lucknow 4, Kota 3, Namakkal 3, Patna 2. Rest are 1, 0, 1, 0, 1.
Do you have the breakup of the top 100 ranks?
Yes.
Top 100 ranks, if you can give us what cities do they come from? Because we have now got the data for the 17, 5 and 4, 9 and 3, 12 and 15 to 17.
Rest would be 1, 0, 1, 0.
Just give us in a chart, you can set it out and give it to us and give it to the others also. That if we take the top 100, which are the cities from which they are?
Our counter affidavit at page 118, we have shared the 100 side also, and we have basically
just give it to us separately right now.
Yes,
you have it right now. Just give it to us
separately. It is annexed to our counter affidavit.
Where is it? It's just page
your counter.
Page number 118.
Counter of NTA.
Items.
Vanshika,
yes, sir. 1 day. Yes. 100 कहाँ से बने? They are spread to 91 places, but these 5 are top. Bangalore has maximum students, 5 who are in the first 500. Rest will be 1, 0, 1, 0, 1, 0, etc.
You said 915.
affidavit on behalf of NTA?
Yes, my lord, 118, annexure R19.
A19.
R19. PDF page 121. Replying. PDF 120.
Okay, 121 is some Bhagatnama.
Annexure
Analysis of top 110.
Counter affidavit on behalf of NTA?
Additional affidavit of NTA.
Additional affidavit of NTA.
The petition number would be petition number 35 of 2000.
Correct. So one Vinod Kumar Sahu is the deponent?
Yes.
Right. Got it. There we have got the annexure A1 is a performance analysis of 17 candidates of Patna, Bihar.
Yes.
A2 is copy of screenshots of messages.
Same.
Now, which is the chart that you refer to?
118. In the entire country, the analysis of top 100 candidates.
Where is that actually?
Annexure
That is
Annexure 19. R19.
118. इधर में तो 118 होगा.
It's continuous page PDF 1070. 1070.
There's no top ranker.
This one 80 cuts.
This is the addition.
Sound.
This is so that here they have given center-wise toppers for all 100.
Right. So first is Guntur.
That's it.
But can your options come to 121?
Here you got it.
We have 121. Please see Lucknow.
See which one?
Lucknow, Lord. Uttar Pradesh, Lucknow, Lord. Left hand side first column, Uttar Pradesh, Lucknow. 2, 1, 1. Your Lordship gets one? Lucknow, Uttar Pradesh is the state, Lucknow is the city, and SDSN Mahavidyalaya is the center. From that center, out of 100, 2 candidates fall into 100, first 100. Then in Lucknow, Loyola International, 1 student, and Uttar Pradesh, Lucknow Central Academy, 1 student. Total up to 4. And therefore, in the report of the IIT Madras, they mentioned Lucknow as 4.
At the same page, kindly see at page 120, there are 9 people, 8 people from Jaipur, which they have not captured in the table. Kindly see the Jaipur bullet, page 120. Jaipur alone has bullet 1, 2, 3, 4, 5, 6, 7, 9 people.
Sir.
They have captured 2. They have not captured 9.
You're right. 1, 2, 3, 4, 5, 6, 8, 9 probably.
Seven people from Bihar were in this.
Uttar Pradesh will get 2 and 1 3 and 1 4.
Yes.
That 3 from Lucknow, 2 from Noida.
Lucknow 4.
Lucknow 4, huh?
Well, the purpose is to show that they are spread over, that in Lucknow, there are only 4 out of total 23 lakhs who appear. Well, just to show that if there would have been any exchange of practice, in one center there would be a spike. That's the intention.
Bihar, there are 7, right?
Yes,
Bihar, there are 7. Yes, sir.
6. State-wise, Bihar, there are 7.
Yes,
right?
Yes, sir.
Then Haryana, how many? Gujarat, there are 1, 2, 3, 4, 5, 6.
Haryana 3. 4. Haryana 4, Millard. And Lord, we kindly notice Haryana 4 is in a situation, if I can be given a moment here.
Yes.
There was one Hardyal school in Bahadurgarh where 8 people were from the same center. And the story of that center is, Lord, the paper distributed in that center, 500 odd student, was taken from Canara Bank. Paper was
It's a different issue.
That's a different issue, but I'm showing you it has a relevancy.
Haryana, there are 4. There are 4 in the top hand.
There were 6 people in the top, which are not, they are not there now. Because what happened in Bahadurgarh, that's one other glaring thing I just want to state here. NTA never disclosed it. That in Hardyal school, Judicial, the question paper taken from Canara Bank was distributed. That paper was taken. There was absolutely no delay in distribution of paper. The principal of the school is on record on YouTube. Even here it can be shown. She says that we collected paper from SBI as well as Canara. Ultimately, the instructions came that you distribute paper from.
Allow me to state it. It's a different issue. We will not fight
that which you have never disclosed on affidavit till now. And I will demonstrate it. That's a very clinching issue which they are getting agitated on. Paper taken from SBI as well as Canara both. The paper was distributed which is taken from Canara Bank. The entire country was giving the paper taken from SBI, but Hardyal School, Bahadurgarh, paper was given, distributed, and ultimately full time was given and paper was taken on the basis of Canara Bank. Answer
that we should call it from.
Now, what happened is, just if I can complete it, what happens is the principal says that after about 40 minutes I conveyed it that we were told Canara Bank and now these students are attempting Canara Bank question paper. Then the instructions to her was that all right, if it's already 40 minutes, so let them do Canara Bank. They did Canara Bank. Ultimately, what they did not disclose it to anyone, but they gave grace marks to everyone in that school. And because of those extra marks, 6 people got 720 out of 720. 2 students from the same center got 718 and 719. Thereafter, this was a grace mark scheme.
Of course, thereafter fish examination was held.
No, that is impinging upon the entire system they had. Now, initially, they arbitrarily gave grace marks for which they were not entitled to at all. Now, this is how they have given grace marks across the country. There was absolutely no justification because they have not come clean on that. Here, they should have said, in Bahadurgarh, a different paper was given. That is why we are holding a re-exam. Fine. First, they said that there was a delay in distribution of paper. There was a loss of time and hence grace marks. When they were caught in this court, Then they appeared before the Honorable Other Coordinate Bench and said, now we are having a re-examination, so please do not go into how we gave the grace marks to this 1561 people. I'm sorry, 1563. So the question that how they gave grace marks to 1563 people on account of loss of time has not been examined by this Honorable Court. They, in their reply, they say that the issue stand resolved because we have had a re-exam. My question is, Lord, that how in the first instance they identify 1563 like the center in Bahadurgarh, and to hush up the matter they say we have a re-exam. Now, Lord, if it was on account of loss of time, they should have given opportunity to everyone in the country. That wherever there is a
Mr. Huda, that is attain finality. Our court dismissed that court upheld the re-examination. Initially they decided to give grace marks to everybody. That was when that was done. There were representations. They said they told us last time that there were representations. Thereafter they decided to revoke that because a fresh committee was appointed and they decided to have a re-examination. Is that correct?
But my respectful submission, I may have to interrupt here only for a moment, my lords. Later. My submission is not this. In the first instance, they indulged into pick and choose for identifying 1563. One classic example is of Bahadurgarh.
Out of 1563, how many make it into the 108,000?
Yes, well, that's an interesting question they have not disclosed. But out of 1563,
tell us. That's the proof of the pudding isn't that. Out of the 1563 who got the retest, how many actually have made it?
Which included 8 top ranker from one center.
We'll find an answer to that.
Now,
see, I've done now in the top 100 re-cities के reputation से आएगी.
कितने हैं?
Huda, when you were arguing, I've just from that top 100, I've done an analysis. The maximum from the states, you said they had disclosed data only for 4 or 5 states. Now, Andhra Pradesh got 7 in the top 100. Bihar 7. Gujarat 7. Just check this up. Ask your team to check it up. I've just done it manually. Andhra Pradesh 7. Bihar 7. Gujarat 7. Haryana 4. Delhi 3. Karnataka 6, Kerala 5, Maharashtra 12, Punjab 6, Rajasthan 19, Tamil Nadu 8, UP 6, and West Bengal 5. That's right. So it appears that the spread in the top 100 marks is distributed across the country.
Yes. Look,
this covers 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 states, and 12 states and 1 UT.
That's right. That's right. On this 1563, I just want to point out one fact. The people who got re-examination opportunity, out of them 73 did not pass the basic marks in the
candidates. Our affidavit, my lord, says first 100 candidates was analyzed and it has been reported that they are distributed across 95 centers located in 56 cities within 18 states and UT also. 69, my lord, in Vanshika Yadav state.
What have you said? That the first 100?
In this regard, I'll just read, my lord. It is submitted that allegation of the petitioner that number of students scoring high marks are only from certain center is completely unsubstantiated. In this regard, the result of top 100 candidates was analyzed and it has been reported that they are distributed across 95 centers located in 56 cities.
Yes.
Within 18 state or UTs of the country. This diverse distribution highlights the widespread participation and competitive spirit among students from different regions and educational backgrounds.
Mr. Huda, this is not only on the other aspects, but if you look at, as they say, first 100 candidates are distributed in 95 centers in 56 cities in 18 states. Apart from that, as we said, the maximum we have taken in students, at least 5 or more per state. 5 or more per state. We find their distribution in 12 states and 1 union territory. That's right. With the highest being Maharashtra, which is, Rajasthan 19, followed by Maharashtra 12, followed by Gujarat and Bihar 7, and Karnataka 6.
Yes, but
For us, my lord,
67. The 67 students.
Yes, they
who secured 720 out of 720.
They are also, my lord, reduced now because of the re-examination.
Now tell us, originally 67 students.
yes, please.
Got
720 out of
720 out of 720.
Yes.
Now, how many of those were in the, I think 17 were in that 1563, no?
Yes. No,
44.
How much? 44?
Initially they are reduced. 7 were there. Reduced.
Yes.
Got reduced to 61 because of re-exam at Bahadurgarh. And it's 44 we are attributing to the aspect of one question paper in which 2 options were marked correct. As a result hereof, it's 44 candidates got the benefit of extra 4 marks, making it 2, 7 and 20. If those 44 are removed, then toppers in the entire country are only 17.
So 44 students got the benefit of the grace marks.
Yes, grace marks.
Not grace marks, full marks for when there was an error in the NCERT book contained the wrong answer.
Hardship is not.
No, there were 2 correct answers. Yes, that's what we'll say here.
So anybody who gave either the NCERT answer or the actually correct answer was given graded as correct.
If they are removed,
they were 44.
Yes, because they will otherwise get minus. Because this is a negative marking system.
Because you didn't go by the NCERT, your booklet didn't go by the NCERT answer, but what was truly the correct answer? They said that, look, the earlier edition of the NCERT book had also this answer.
Now,
so you treated both as correct answers.
Yes.
And those are 44 students.
And total, my lord, are otherwise 17, which in a multiple choice question, my lord, framework is possible in that out of.
So now, as it stands, 61 students across India get 720 out of 720 today.
Yes.
Out of which 44 students have got the benefit of that one question where there were 2 correct answers were treated as the correct, 2 options were treated as correct answers.
So you cannot read them.
17 remains.
So balance 17 really.
If 44 are
the real purpose.
100% students.
No expertise.
Now tell us one thing, out of these 61 students who have now got 720 out of 720, or let me put it this way, in the top 100, are there any cases where students had changed their centers? In the entire exam, Mr. Kaushik, how many students changed their centers in the entire exam? 23 lakhs. We'll go step by step. In the 23 lakh, total number of students who appeared were 23.33 lakhs. How many students had changed their centers out of the 23.33 lakhs?
Yes, the center allotment is only on two aspects, only two factors. One is permanent city and the current city residence. We do not give any specific option with regard to the change of center. Let the correction window is opened up. In that, the field may be changed by the candidates, which will not come to our knowledge.
So that will be permanent or the current city?
Yes, it's only two options.
So once you are registered, you can't change your center.
Next, what they do is, in the name of corrections, some students change the center also, correcting the parameters or the fields of the application form. We give correction window for some time. During that process, only the possibility of change of center.
But you will never know it.
No minutes. So that also has to be on the basis of the address.
But you don't have the fields which are originally filled in by the student and the corrected fields.
So far, as of now, the system doesn't catch that.
So we don't know how many students actually changed their centers when the window for correction was open.
We know the correct number of the students who utilized the reopening of the window, in which 15,000 students utilized the correction model.
No, one second. 15,000 students utilized the window which was kept open for making corrections in their applications.
And we have
now, of the 15,000, how many had corrected the field of the center?
They shy away from
one second.
Also.
Yes.
But for them, that they should open this window. Rajasthan High Court
window to correct the fields. The window to correct the fields. How many days was that window kept open?
2 days only.
What are the days?
Well, 9th and 10th of April.
9th and 10th?
Not for correction. This is not for correction, my lords.
One second. We'll ask them.
This is actually incorrect.
1 second, Mr. Kaushik. The window to correct the fields. How many days and when was that?
24. List of dates. On 8th of April, page 99 of the 99 direction.
Now tell us one more thing. The candidate, when the candidate fills in the application form online, does the candidate have to fill in the city or center? City only. Center is allotted by NTA, by the computer. So what they can change is the city, right?
Yes.
Okay. So if a candidate has, say, filled in Guwahati, that candidate during that window can change it from Guwahati to Lucknow.
Yes.
But no candidate can decide on the center. Is that correct?
Actually,
centers are allotted only by NTA. Just check, is that correct?
Yes.
By computer system or
by the computer system.
Center allotment is only 2 days or 3 days before the exact date of exam. So nobody would come to know which center is going to be allocated.
But that's not an issue. Center will be in the same center.
To correct fields, you were saying?
March to 20th March, 1998.
Is it correct? 18th March to 20th March?
18th March to 20th March and 11th April to 15th April.
All right, 1 second.
11th to 15th was additional. New people came in 9th and 10th.
And 11th to 15th?
Yes, it's apparently 9th and 10th. 9th and both.
Now tell us one thing. How many came in? How many corrected their fields 18th and 20th March.
That MITS data is to be found out.
But you said that 15,000, no?
That is MITS when additional slot was opened on the basis of the court orders and representations. Further time was given to make fresh applications.
In April?
Yes, please.
So 15,000.
Yes.
24,000.
No, all right. 8th April to 15th April. 11th April to 15th April, you said, no?
No, 8th April to 10th April.
No.
Correction window is 8th to 15th.
Notification was 8th April dated, and the window was open for 9th and 10th for new registration. For new registration, not for correction. And for correction, which, sir, I am reading for you from your affidavit.
What do you read?
I was at page number 99.
Just read it.
Page number 99. This is a public notice dated 13th March 2022. The subject is correction in particulars on the online application form of National Eligibility cum Entrance Exam UG 2024. Now, my lord, I am reading the box, the relevant part. NEET 2024 UG. Duration of correction 18th March to 20th March 2024 up to 11:50 p.m. Field for correction. So he is even not disclosing that what field. It was specifically mentioned that field for correction is as per annexure A, and that annexure A was not. Annexure A was filed on the next page. All fields. This is very important.
So between 18th and 20th March, you could correct all fields.
All fields and update documents except the contact mobile number, email. So other than everything else.
Now, which was the second window? We got the first window, 18th to 20th March. What was the second window?
The second window is 9th of April and 10th of April. For 2 days, the second window opened for a new application, a new registration.
At page
that was for 15,000. They will not say that this is unprecedented. It never happened earlier. They say that they were directed to do this by the Rajasthan High Court. Rajasthan High Court order is on record, which pertained to only one candidate. And High Court said, for this candidate, you permit him the registration.
So 9th and 10th April 2024, you say there were 15,000 fresh registrants.
24,000. As per our information.
Now, let's ask Mr. Kaushik. Now, 18th to 20th March 24, how many corrections? That is the window for corrections. Do we have figures about that?
That we will have to work out.
All right. And 9th to the 10th of April, how many new applications came?
That, according to our information, we have given the data minutes 15,000 applications. New applications were received.
We'll take your data. Your official data.
And my lord, one more important change of center is concerned. The petitioners have bullets focused only at Godhra. In Godhra, the change of center was by only 34 persons, out of which only 16 could be allotted the change of center.
They are not getting any admission.
They are not getting bullets any.
So come again for change of centers.
Yes.
Was by NTA, you changed the center.
By the candidates, by the
permitted change of.
Yes. No, but you took it that the candidate has no choice of change of center.
Correction of city. I stand corrected.
City.
Right. So,
for example, Jaipur to Godhra. And out of.
So, do we have any data on how many students all over the country? Say in the first 1,08,000, we'll now focus on 1,08,000, no better, had changed their cities.
We will get that data, but we have got the data of Godhra only. That's because the Godhra was the only.
So, how many of the 1,08,000 would have changed their cities? We would like to know that.
That will be possible.
And we would also like to see the distribution of which were the cities that they changed. Was there any change in respect of one of these suspect areas? Like Hazaribagh or Patna, or is there any concentration in the change of cities to specific cities?
No, there is one interesting statistic.
That will give us some idea.
I have seen one.
Is there any skew in respect of those who got registered between the 9th and 10th of April 24? So after lunch, we're just short of lunch. We'll just break for lunch. After all this mental exercise, we also need a little lunch. But what we want to know is this, that those who changed their centers, how many of those have made it to the 1,08,000? That's one. And second, is there any skew in favor of those who had changed the cities on the 9th and 10th?
We have, let's roughly work out.
Some people change their language. Some people change their language. They said, please give us a Gujarati medium, for instance.
What language? Just
that,
give us also language.
That
so concentrate on 9th and 10th of April. How many students change? How many of the fresh registrations? For fresh registration also could change their centers?
Yes. Fresh registration date is after which
when they change the center during that period.
New application is totally different. New applications are completely different.
Can an old student
one more. Only confined to one student. Then how did you open up the portal for on 9th and 10th of April 2024 beyond that one student? Yes. As a result of which 15,000 students registered. Just 1 second, we have something very important. We'll forget it otherwise. Out of the 15,000 students, how many are in the 1,08,000?
Correct. The reason is, I can give...
Mr. Kaushik, just talk to your staff at lunch and come back after lunch.
Here, I think our discussions are going a little off. But I may be permitted to address your lordship for just 5 minutes.
Of course. Who said no?
No, before you further proceed, below. I was patiently listening everything because I think the whole issue is
one second.
Yes.
One of your colleagues is in.
No, I only want one sentence to be permitted.
After he finishes, we'll hear others.
No, I only wanted to say one sentence. Hear me in one sentence full.
One sentence.
One sentence only. The whole question before the court is whether the test should be examination be cancelled or and a re-examination to be conducted. The discussion is far away from that.
No. This is the heart of it. We have to look at the evidence, the underlying evidence in the record to see whether
But that is a major administrative decision. It is not depending on a minor irregularity here or there. It's a major administrative decision. For a minor irregularity here or there.
All right. Mr. Nedumara, 1 second. We were a little confused. Are you on this side or on that side?
I am for the petitioners and my submission is...
You are saying no retest?
No, absolutely. The only way is to conduct a retest.
Okay. Then that's...
And I want to use a very soft terminology. Very soft terminology. I discussed with the IIT professor. He used a strong terminology. I'm not using it. He used the terminology the professor used was the IIT report. He said, there are 3 types of lies, damn lies, and now IIT report.
Data. Let's not.
I'm not using it. I'm not saying that.
Use adjective.
No, I'm not using.
That's not fair, Mr. Nedumara. Also, 1 second. Let's not just damn it's Premier Institute. It's so easy to say something about a Premier Institute. Give us core facts.
No, I'm very soft on them.
Give us core facts.
If my lord were to hear the full facts, I can point out just one aspect. Exam, my lord, if I can just say one aspect before my lord.
All right, we'll come back after lunch. Yes, man. Your Judges Association, man.
Scope of your lordships can take...
Definitely. We'll keep it in the first week of August and we'll take this up because a lot of matters across India are dependent on this.
Pending.
Thousands.
The thing is, because this matter, the canon matter was passed by 3 judges.
Right.
Therefore, it has to be.
It has to be 3 judges. It will be before this regular bench. Yes. It will be before me and my 2 colleagues. So we are seized of the matter.
As it pleases.
Item 3 is Google matter.
I appear for Google. Your lordship recalls your lordship.
What we'll have to do is, are the compilations ready in Google?
Yeah.
Everything is done. Give dates in September.
Today, Mr. Salvi, only because we have the Neet matter and literally lakhs of people all over the country are waiting for the outcome of this matter.
No, in September, Malad. Give dates in September.
Probably in the first week of September, so that we can conclude.
Malad, a little later, I have the Indus Valley dispute before the neutral expert in September.
Second week of September, Marathon.
After 15th, Malad. After 15th, any day.
Submissions have not been received, the court master says, so you'll have to email them.
That will make sure are sorted out.
Why don't you give us on the side of Mr. Salvi one nodal counsel?
Lordships, yes, I filed it. We filed it on the 3rd of October. We'll file it again. We'll send an email again. It's been filed.
All right. Who's the nodal counsel on your side?
So Mr. Chandelia is the nodal counsel.
Mr. Chandelia. And what about Mr. Venkatraman, your side?
I've already said in the
We've already appointed nodal counsel. All right. Then make sure that is filed by the 31st of July. All right.
Yes.
Gaming matter.
This again, Malad, is the gaming matter.
Are these absolutely ready for
Union Mellots has filed its counsel. Lordship had directed Mellots to be filed appointed nodal counsel. That has not been. We can do it in a week.
We set down 31st of July for completing the filing of the compilation.
Yes.
Maybe 15th August may be better, Malad, but
anti-profiting batch we can exclude, but amongst gaming, no segregation, Malad. Everything has to be heard here.
Agreed. My friend is right.
One second.
15th August may be better.
This exercise has been done in the registry.
Yes.
The gaming matters we've got separately listed and the anti-profiteering matters are separately.
Correct.
So they have to be segregated. Now, what we will do is that the learned counsel can. This is being done by Charanya.
The list is made. Charanya has made.
Look at it.
Just check it up now. Just give it to me now.
Ms. Charanya Lakshmi Kumaran, learned counsel appearing on behalf of the petitioners, some of the petitioners, has prepared has prepared a tabulated statement segregating into a single inverted commas, gaming into inverted commas matters from the into